The average estate spends 16 months inside a probate court before your family sees a single dollar. Most people think probate is a formality. Sign a few papers, wait a few weeks, done. It is not. The court freezes your assets. The day you die, your house, your accounts, your savings stop belonging to anyone. They belong to a process. A judge opens a file. Strangers, creditors you never met, get a window to collect before your spouse or children see anything. Then someone must find every asset you owned, value it, and report it under oath. Only then does a dollar move. This is not rare. Own a house, an account, a car in your name? Your estate enters this exact sequence, unless you built a structure around it. And here is what should stop you. How long it takes is not random and not up to your family. A small set of facts in your paperwork decides it. Some add 4 months, some add 4 years. By the end, you will know which is yours.
The probate court is not a courtroom in the way you picture one. There is no jury, no opposing counsel pacing in front of a bench, no verdict read aloud. It is closer to a queue at the DMV, except the line does not move on a first-come basis, and the form you filled out years ago is what determines where your family stands in it. Most people hand in a will that, without realizing it, puts their spouse and children near the back. Here is the mechanism. When you die, your assets do not pass to your heirs. They pass into something called the estate, a temporary legal entity that exists for one purpose: to be sorted, valued, and distributed under court supervision. Your will does not skip this step. Your will is simply the instructions the court follows once the queue starts moving.
Justia's overview of probate administration describes this directly. The court's job is to recognize the will, appoint someone to run the estate, and supervise that person until every asset has been accounted for and every creditor has had its turn. Notice the order: creditors, then heirs. Think about what that means. The people who loved you stand behind the people you owed money to. That is not a metaphor. That is the order of operations written into the system every estate enters. And the position your family holds in that line, close to the front or stuck behind a dozen procedural steps, is set the moment the court opens the file. Which raises the only question that actually matters here. What exactly opens that file? And how fast does the clock inside it start running? Most people assume the legal clock starts the moment a person dies. It does not. It starts the moment someone walks into a courthouse and files the will. That single act, a piece of paper crossing a clerk's desk, is what converts a death into a legal proceeding, with a fixed sequence and a fixed set of deadlines that your family no longer controls. Until that filing happens, nothing moves. Not the bank account, not the house, not the car in the driveway. The American Bar Association's overview of the probate process lays out what comes next in order. The court validates the will, formally appoints an executor or personal representative, and only then does that person gain the legal authority to act on the estate's behalf. Before that appointment, your spouse cannot sell the house. Your children cannot close the bank account. Legally, no one can act, because legally, no one yet has the authority to. And here is the detail almost nobody checks until it is too late. The appointment itself is not instant. It requires a hearing date, a notice period, sometimes a bond. In some counties, that is a matter of weeks. In others, it is months. And the backlog of the local court matters more than the size of the estate. 2 families with identical paperwork in 2 different counties can wait 2 completely different lengths of time for the exact same first step. That is not a difference in your will. That is a difference in which building your file landed in. And once that file is open, the next thing that happens is not distribution. It is a freeze. And that freeze is where most families first feel exactly what probate costs them. The moment the court opens the file, your assets stop being yours, and they do not yet belong to your heirs either. They enter a kind of legal suspension, frozen in place, untouchable, while the court determines who gets to move them and when. Your spouse cannot write a check from the joint account if it was titled in your name alone. Your children cannot sell the house to cover the funeral, the mortgage, or their own bills. The asset still exists. It still has your name attached to it. But for as long as the estate remains open, it is functionally locked. This is the part that catches families off guard, because it contradicts everything they assumed a will would do. A will does not transfer property at the moment of death. It is a set of instructions the court executes only after the estate has been opened, inventoried, and cleared for distribution. Fine Law's breakdown of the probate timeline notes that even straightforward estates typically take 6 months to a year to move through this sequence, and that is the version without complications. The freeze is not a side effect of probate. The freeze is probate in its first and most immediate form. Think about what that means for a family that depended on that account for groceries or that house for shelter. The asset is there, the need is immediate, and the law says, not yet. Not until the next stage clears, a stage most people have never heard of, where total strangers get a formal, court-protected window to step in front of your own children and collect what they say you owe them first. Here is the part the family almost never sees coming. Before a single heir receives a cent, the court has to hold the door open for creditors, and not informally. Every state requires a formal claim period, a fixed window of time during which anyone who says you owed them money can file a claim against your estate. The executor has to publish a notice. The court has to wait out the clock. And until that window closes, the estate cannot be distributed, because the law has to know exactly how much of it creditors are entitled to take first. This is not a courtesy extended to your family. It is a legal protection extended to strangers.
The Trust and Will Overview of Probate Costs notes that these mandated windows are one of the central reasons even simple estates routinely stretch past the 6-month mark. The court is not slow by accident here. It is slow on purpose, because the law has decided that a creditor's claim deserves a guaranteed amount of time to surface before your children can be paid. And here is the consequence that compounds quietly underneath all of it. Every month the estate stays open costs money. Legal fees accrue. Executor commissions accrue. Filing fees accrue. None of that comes out of the system. It comes directly out of what your family was going to inherit. The creditor window does not just delay the payout, it shrinks it, one billable month at a time. Which brings the next, harder question into focus. Before any of that money can move anywhere, someone first has to find every single thing you owned and prove it, on paper, to a judge who has never met you. Most people picture the executor as someone who simply hands out what is written in the will. That is not the job. The actual job is closer to an audit. The executor has to locate every account, every property, every policy, every debt, and then have each one formally appraised and reported to the court, in writing, under oath, before distribution can even be discussed. Justia's description of estate administration is direct about this. The personal representative is legally required to compile a full inventory of the estate's assets and submit it to the court as a condition of moving the process forward. Now picture what that looks like in a real household. A checking account is easy. A statement, a number, done.
A house requires a licensed appraisal. A small business requires a valuation. Stock options, old retirement accounts from 3 jobs ago,
A storage unit nobody has opened in a decade. Every one of those has to be found, valued, and justified on paper before the court will move to the next stage. Miss one, misvalue one, and the court sends the filing back. The clock does not pause to be polite about it. It keeps running, and the bill for the professionals doing this work keeps running with it. If you want to know exactly how exposed your own estate is to a delay like this, do one thing this week. Subscribe, because the next mechanism in this series walks through the single document that can cut this entire inventory stage down to almost nothing, and almost no one has filled it out correctly. Because here is what nobody tells families going in. The inventory itself rarely breaks an estate.
What breaks it is what happens when one person in the family looks at that inventory and decides it is wrong. A single sentence can take a 4-month process and turn it into a 4-year one. That sentence is, "I don't think this will is valid." The moment one heir files a formal challenge, claiming undue influence, questioning a signature, arguing the deceased was not of sound mind when the document was signed, the entire administration stops being a paperwork exercise and becomes active litigation. The court is no longer processing an estate. It is hearing a case. This is where probate stops resembling a queue and starts resembling a trial. Depositions get scheduled, evidence gets gathered, hearings get continued, then continued again. The Wiles Law Firm's overview of common probate disputes notes that contested estates are precisely the cases that stretch on for years rather than months. And during every one of those years, the freeze from earlier in this video stays in place. No one gets their inheritance while the fight over who deserves it is still unresolved. And the reason has less to do with how much money is on the table than with whether the people fighting over it can stand to be in the same room. Think about that. The legal fees generated by a will contest do not come from some outside fund. They come out of the same estate everyone is fighting over, which means the longer the fight lasts, the smaller the prize gets for everyone, including the side that wins.
And there is one asset inside almost every contested estate that turns this fight from bitter to brutal faster than any bank account ever could. The house nobody can simply sell, split, or walk away from while the lawyers argue over who it belongs to. Most people assume a house simply passes to whoever the will names. It does not. Not directly, and not quickly. Real estate sitting inside an estate cannot be handed over like a set of keys. In most cases, it has to be formally retitled through the court, or sold through a court-supervised process before it becomes anyone's legal property. And a house is not a number on a screen. It is a physical asset that has to be maintained, insured, sometimes occupied, and eventually transferred, all while the legal machinery moves at its own pace underneath it. Here is where the timeline quietly multiplies. Florida Probate Law Group's Guide to the State's Process notes that when real property has to be sold as part of administration, the court often requires its own approval of the sale terms, meaning a buyer cannot simply close on a house the way they would on the open market. The estate has to find a buyer, get the court to bless the price, and clear the transaction through the same office that is also processing the inventory, the creditor window, and every other moving part of the file. One delayed signature on any of those tracks can stall the property sale by weeks. And here's the cost most families never see coming until the closing statement arrives. Every month that house sits inside the estate, someone has to pay the mortgage, the insurance, the taxes, the upkeep, out of an estate that is not yet allowed to distribute a dollar to cover it. The house is not an asset during this stretch. It is an obligation wearing an asset's face. And that obligation is just one entry on a bill that has been quietly running since the day the court opened the file.
a bill with an exact percentage attached to it, one that almost no family calculates until it has already been subtracted from what they were promised. Here is the number that should change how you think about every month this process drags on. Probate routinely consumes somewhere between 4 and 7% of the total value of an estate before it ever reaches an heir. Trust and Will's breakdown of probate fees lays out where that percentage actually goes. Attorney's fees, executor commissions, court filing costs, appraisal charges, and the accumulated expense of simply keeping the estate open month after month. None of it is optional. All of it is subtracted before distribution, not after. Run the number on a $250,000 estate and you are looking at somewhere between $10,000 and $17,000 gone. Not to taxes, not to creditors named in the will, but to the cost of moving the paperwork through the building. And that estimate assumes nothing goes wrong. Add a contested will, a property sale, or a backlogged county court, and that percentage does not stay flat. It climbs because nearly every fee in that list is calculated by the hour or by the month, and every delay you have just learned about adds more hours and more months to the bill. This is the part that should sit with you. The length of the process and the cost of the process are not two separate problems. They are the same problem measured two different ways. Every extra month the estate stays open is not neutral. It is actively converting your family's inheritance into someone else's invoice.
And that raises the only question that actually matters from here forward. Is there a way to keep an asset out of this machine entirely? Not every asset you own has to go through any of this. Some of them can walk straight past the courthouse, the freeze, the inventory, and the fees. And the mechanism that lets them do it is sitting in a filing cabinet in your house right now, filled out wrong or not filled out at all. It is the beneficiary designation, the joint title, the trust document. These are not loopholes. They are the actual statute, written specifically to let an asset bypass probate by transferring ownership the instant a death certificate is produced. No judge, no inventory, no waiting period. Here is the part that catches even careful people. A beneficiary form attached to a retirement account or a life insurance policy overrides whatever your will says about that same asset, not influences, overrides.
The American Bar Association's overview of the probate process notes that property passing by beneficiary designation, joint ownership with survivorship rights, or through a properly funded trust generally avoids the probate process altogether. It transfers by operation of the form itself, immediately, outside the court's authority. The form wins, every time. And here is what almost nobody checks until it is too late. That form was likely filled out once, years ago, at a job you no longer have, naming a person who may no longer be in your life. It has not been updated since.
Which means the single document quietly deciding whether your family skips this entire process or walks straight into the middle of it may currently be sitting in a drawer, pointed at the wrong name. Strip away every detail covered so far, and one structural fact decides whether your estate clears the courthouse in 4 months or 4 years. How much of what you own is positioned to bypass the court before you die versus how much is left for the court to process after. Find Law's overview of the probate timeline points at this same variable from the legal side, noting that the length of administration tracks not the size of an estate, but how much of it requires the court's involvement in the first place. That is the entire variable, not the size of the estate, not how much your family loves each other, not even the state you live in, though that shifts the numbers at the margins.
It is the structure of the paperwork,
set years in advance, usually without anyone realizing it was a decision at all. An estate built almost entirely around beneficiary forms, joint titling, and a funded trust can move through administration in a matter of weeks, because there is barely anything left for the court to freeze, inventory, or distribute. An estate built around a will alone, with no other structure underneath it, walks directly into every stage this video has described, in full, in order, on the court schedule, rather than the family's. Same death, same family. Two completely different timelines, decided entirely by which structure was in place the day it mattered. This is not a detail. This is the determining factor. The one fact that more than any other decides how long your family waits and how much of what you built actually reaches them. And once you understand that the structure is the variable, the only honest next question is the one almost no one asks while there is still time to answer it. Which structure does your own paperwork currently point toward? So here is the full picture, back to where we started. Probate is a queue, and the position your family holds in it, close to the front, walking around it entirely, or stuck behind every stage you just learned about, is decided by paperwork you likely filled out years ago and have not looked at since. The freeze, the creditor window, the inventory, the risk of a contest, the property trap, the 4 to 7% drain. None of that is random. It is the default sequence for any estate that was not deliberately structured to avoid it.
I built a printing business from nothing, and I learned early that the man who controls the paperwork controls the outcome. The courthouse runs on documents, not on intentions. Your will tells the court what you wanted. Your beneficiary forms, your titling, your trust, those tell the court what to do, immediately, without asking permission. 100 years from now, my face will still be on the bill. The form deciding where that bill goes when you're gone is sitting in a drawer in your house tonight. Check it this week. And if you want to know exactly what happens when no will exists at all, when the state itself decides who stands at the front of that line, subscribe, because that is the mechanism the next video takes apart, piece by piece.